Okay. So good evening, everyone. I, C. Pranav Mantri, moderator of this webinar. Delighted to welcome all in the webinar being organized by CCLEA and NPO Committee of ICI. It is my utmost pleasure to be the moderator in the webinar on Intricacies on Will Drafting, which we are hosting on 26th of June 2025 from 5 p.m. to 7 p.m. being organized by Committee on Commercial Laws, Economic Advisory and NPO Cooperative ICI. In a short while, we'll start with this webinar. But before that, I take this opportunity to quickly tell you something about our CCLEA and NPO committee. This committee is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value while combining analytical foresight with commercial acumen. One of the core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formulation, to develop and publish the technical guidance, background materials, and to create awareness for professional opportunities for chartered accountants in commercial laws, economic advisory, and NPO cooperatives. Our eminent speaker, Dilip Sadbhai sir, will talk on intricacies on will drafting in this webinar, and we hope that the same will be really very useful to all our members who are present here. I welcome you, sir, for this wonderful webinar being organized by the committee. Before we start with this webinar, I take this opportunity to introduce our multi-talented speaker for the day, CA Dr. Dilip V. Sadbhai. Sir is the senior partner of Messrs. D.V. Sadbhai and Co., having its office in Pune. He is the firm's senior partner and was the vice chairman, secretary, and treasurer of the Pune branch for the Western, which falls under the WIRC. He was also co-opted member of various committees of the Central as well as the Regional Council of ICAI and have served in New Delhi as well as in Mumbai for multiple years. He was selected as the faculty member of the Institute of Chartered Accountants of India to deliver lectures on GST on pan-India basis under FYP and was even appointed as the co-winner of the Pune GST Study Group, a local think tank for studying the GST law and helping the needy taxpayers. So has been into even writing, and I know him personally because we both of them have a common passion towards writing. So we write for Sakha newspaper and even we write for Money magazine. So his writings are very much applauded at all India level, and even at Maharashtra level, he has been felicitated with multiple honors looking at his writing passion. Even coming to his post-qualification courses, post-qualifying, he has done multiple courses: international taxation, forex and treasury management, NPO, AI, wealth management, and the list goes on and on. I really wonder, sir, how much time do you get? Even he has published his books along with ICI on Handbook for Chartered Accountants to Draft a Will and Handbook on Nomination Intricacies. He is the honorary treasurer of the International Legacy Union and Allied Health Alliance, the NGO which is formed to eradicate leprosy. He has been even a lifetime founder chairperson of Usha Lele Charitable Trust and PD Lele Pratishthan, Pune and Mumbai. He is also the trustee of Kalavardhani Trust, formed by Sucheta Chapekar, who is a well-known Bharatanatyam classical dancer. He is even the director of few of the Section 8 companies. He even has his own YouTube channel wherein he promotes and spreads awareness about the different topics which comes under the taxation as well as non-taxation and the finance domain. So I am really glad that I get this wonderful opportunity to introduce you, sir. Without further ado, I hand over the stage to you. Over to you, sir.
Thank you, Pranav, for the brief and very good-worded introduction. You have always been a source of inspiration for all the Pune branch members, including me. So everybody knows about that whenever some introduction and other things are required to be carried out, only one name comes in front of Pune branch, and that is Pranav. So everybody knows the contribution of Pranav every now and then. And that is the reason why you are being unique so far as the Pune branch is concerned.
Thank you so much, sir. Coming from you itself means a lot because you are an inspiration. We all young chartered accountants look up to you. And looking at your age, I've always seen you smile at each and every event. So it's really wonderful. And you are a source of energy for all of us.
Thank you, Pranav. Let us start with now the topic that what we ultimately are designed to discuss for. So initially, I must thank the chairman of the Committee on Commercial Laws and Economic Advisory, NPO Cooperatives, for inviting me to deliver a lecture on intricacies on will drafting. I'm also thankful to the past chairman of the committee, Sri Chandrasekhar Chitale, who ultimately made me to contribute towards the handbook, which ultimately will be meant for chartered accountants. And I'm also thankful to Sri Abhay Chajetji, who has ultimately gifted a good gift for me as soon as this handbook for will drafting was published by the institute in itself. So thanks all committee members. I'm also grateful to Mayank sir, who ultimately every now and then contacts me and tries to fix up a meeting as and when committee needs it. So I'm also grateful to Sri Mayank sir for inviting me for this particular webinar as well. So let us begin with the preliminary part of the intricacies those are involved in will drafting. As you all know, that life is all about planning, and it is planning for uncertain future, which is one of the most significant uncertainties in life. And what is more important there is the timing of death. So nobody knows that when you are going to die and when you are going to live and how long you are going to live in itself. So we come across of sizable products which guarantees when you are alive and when you are no more, because we see the dictums like Jindagi ke saath bhi, Jindagi ke baad bhi. So these are the things which products which ultimately help us to overcome this particular matter. And that is the why if humans have property and assets, it makes sense to plan the management and distribution of these properties after the demise of the individual itself. So no one can predict, as I have already made it out, that when the person sitting in the chair will be hanged on a wall in the form of a photo, along with the garland of sandalwood flowers around the photo frame. Uh, those are lucky who will be having a sandalwood garland, but there are many people, they are only hanged in a photo frame, ultimately with no garland in itself. But this is the reality which we need to accept, and this is the very uncertainty in life that which one has to tackle very skillfully, and then one can ensure the transfer of or disposition of property to their loved ones according to their wishes, if such person ensures the memorandum. And this is the area where the will comes into picture and wills becomes very, very important. Now, what is a will be a general preposition. So we have learned about that, why will is required, what is ultimately the thing, because death is uncertain. Nobody knows the property which you have generated ultimately reach ultimately to the loved ones, which are either adolescent, minor, or major, as the case may be. So you need to distribute that property in equal proportion. So in such cases, how that can be done is being tackled with the help of will. And that is the reason why will is very much required so far as the technicalities are concerned. Now, a will is a legally binding document. Why will is required? What is will? Now, when you prepare a particular document, the first important thing that what we need to make it out that whether it is legally binding on the persons or not. And that is the reason why Hindus, this is Indian Succession Act 1925, specifically says that it's a legally binding document that outlines how your assets will be distributed after your passing off, and can appoint guardians for the betterment and management of the life of minor children. So the basic important thing is that whatever document you will be preparing, it will be having a backing of Indian Succession Act 1925. So legal backing weighs a lot so far as the technicalities are concerned. then this valuable document enables you to clearly express your wishes, because during your lifetime your wishes ultimately goes on change. Today you are thinking about one thing, the other day you will think the other way around. But when you specifically say your finalities, the wishes in finality, those are required to be specified in the document in itself, and those are your wishes which can be brought into reality over a period of time. In the absence of a will, the laws of your country of residence will dictate how your estate will be divided amongst your legal heir, a situation which ultimately would be known as if you are dying intestate. So dying intestate and dying testate, these are the two important words which we need to understand. Then when you die without making a will, when you die without making a will, it is called as intestate succession. And when you die with after making a will in itself, then it is a testate succession. These are the words which you need to understand and need to keep it in mind in itself. So let us proceed further and try to find out now what are the important features which we need to understand and which we need to learn so far as the technicalities are concerned. So in the light of that now, hold on for a second. What is a will? A will is written to a text matter document that specifies how your possessions are distributed after your demise and can designate guardians for your young children. A will is useful legal document because it allows one to declare their objectives articulately, dealing them carefully with the professionally drafted and or amended desires and wants. So these are the two important features which we need to make it out. When there is no will for someone, it is the nation from where you belong to decide how your properties are given to your successor based on its regulation. So it is a specific country oriented rule that ultimately prevails. If you are in India and die in India and you are an Indian citizen, then accordingly you will be governed according to Indian laws. If you are staying outside, citizen of some other country, the place where you reside, the country ultimately will decide how the property will devolve upon the legal heirs. This is regarded as dying intestate, and the agreement that follows doesn't always generate the consequences you want to your family. So you can avoid this by having documents prepared that match to your preferences, and that is what will is all about. Let us see the definition of will in the Indian Succession Act 1925. Section 2 small h defines the will as the legal declaration of an intention of a testator with respect to his property which he desires to be carried out into effect after his death. So two parts are being there. It is the legal declaration of intention. So it is the intention that matters so far as the will is being concerned. It is pertaining to the property and ultimately where and how the effect of this particular death, the property will default is the third part which you need to understand and need to remember. So other definitions are there which we will not talk about. Now, why will should be prepared will be the major issue that we will have to look into. And there are some 6, 7 important reasons which ultimately will decide why will is required to be prepared. The first important point which we need to understand is about death. The only reality in our life is death. That death is certain. Whatever certain thing that what we can come across is about the reality, and the death is the certainty which you can predict so far as the matter is concerned. Every day around 150,000 people are dying due to old age in the entire world, of which nearly one-fifth die in India. It means that in India, around 100 lakh people die every year due to old age. So the total dictum that what we will have to look into, that every year around 1 crore people are dying, and they are making will or not, that we'll see at a later point of time. deaths due to hunger in India is around 25 lakh, which is enormous. Nearly 462 people die daily in a road accident in India, which is a world record. From 2014 to 2021, nearly 98 lakh people have died because of insufficient or insufficient medical care in addition to COVID-19 victims. Every day, around 28 farmers are committing suicides, where number is more in Maharashtra. Thus, when one will die is not known, and hence, in order to ensure proper handing over of the property to the desired beneficiary, will is required. That is the first ingredient that what we need to make it out. That death is certain, so you need to make it out that when you are going to die, timing of the death, though may not be known, ultimately you should be prepared for the death in itself, and that is what the major issue which we need to address. Then the second important point why we should prepare a will is that property without known legal heirs. The report of the government states, this is the government report, that due to inability of owners to transfer the property through proper channels to relatives, in absence of known legal heirs, the government is holding property worth more than 50,000 crores undistributed. So here the property was there, the people were there, legal heirs were there, but since the legal heirs were not known, the property worth rupees 50,000 crores has remained undistributed, which is a matter of concern and which is still lying idle or unattended since very long, which otherwise would have changed hands had there been a valid will. So this is the second reason that your property should not go to the government and it should reach to your legal heirs in itself. Will be required in itself. First is about death certainty, and now about the legal hair that I just mentioned about. Third is the why will is being required, because of the eradication of financial illiteracy is being required. In India, as per the report, only 9% to 10% of the people only draft will in itself, and they write about their wills, as against 46% to 60% in United States of America and other Western countries. So I have already told you that nearly 1 crore people die every year in India due to old age, besides other categories. So around 1.5 crore are being dying every year, and only 9% thereof or 10% thereof, hardly 10-15 lakh people are preparing their will. The remaining 1,35,000 people, they are not at all preparing. 1 crore 35 lakh people, they are not at all preparing the will, which is creating a chaos and which is resulting into difficulties in the matter. So if the percentage are compared with the US and Western countries in itself, you will notice that we are only 20% of what the Western countries have been doing. So that is where the deficiency is there, lacuna is there. There are certain challenges most individuals face when it comes to estate planning. So nobody talks about estate planning so far as the succession planning and estate planning is being concerned. And that is the gray area which we need to address. That is the reason why will be required. Many wills lack in one or more elements, such as not following the procedural requirements, not updating the will in a timely manner, otherwise as a result of which the property is already sold out, still it is there in the will in itself, becomes useless so far as the execution of will is concerned. So similar other matters are there. Many individuals are still associated with the idea of writing a will to death. So everybody thinks about that, I'm not going to die soon, so why I should prepare a will? That should not be the case. We need to prepare will as and when we feel that there is a property and there are legal heirs which ultimately are likely to receive. So in order to keep better life of our descendants in itself, it is necessary to prepare a will in itself. Some think that will writing is what rich people do. So only those who are having the properties in itself, only the rich people are there, they normally do this type of thing. But that is not the case. Everybody should do and prepare a will. For your example or for your information, I may specify that at the age of 35, I have drafted my will incorporating all the property that I inherited from my parents, inherited from my other friends in itself who donated certain amount for my trust, and the other issues so far as the self-acquired property was concerned. So keep always updated in these particular lines. But most ignore the fact that it enables the asset owners to transfer asset to the person they choose after the death of asset owner. So this is the major issue that we need to address, that the property will go only to the desired person to whom ultimately the owner of the property is thinking about. These misconceptions arising from financial literacy are the major reason for not drafting and preparing a will. Hence, to overcome the misconception about wills, mass awareness of financial literacy would be required. And that is the reason why the wills are not getting drafted. Illiteracy needs to be removed. Then coming to the fourth important point, why will should be prepared? The unforeseen may happen. Not having a valid will leave the family of the deceased vulnerable to unwanted legal exposure. Nobody knows when you will die. When the snake will bite and you will die, nobody knows. When heart attack will come and you will die, nobody knows. And in that particular category in itself, the family members are ultimately being put to difficulties in itself. And that is the reason why there is a high risk of poking assets by the deceased, by distant relatives of the creditors are concerned. So when nobody is there to ultimately look after your loved ones in itself, some miscreants ultimately poke up the assets in itself, and ultimately the relatives and other things who ultimately are interested in the property take advantage of that, but that can be avoided by preparing a will in itself. So that is the major area which we need to understand. Then very often the total assets are deceased are not known to the family members, because the male member who earns the property in itself and money in itself never discloses this particular matter to the loved ones in itself for variety of reasons, and which ultimately makes the concerned person very vulnerable to not being disclosing this particular matter, and the entire family is at risk because they don't know anything how many properties that they own and how many properties ultimately are required to be passed on from the deceased person to them in itself. I have come across a sizable number of cases in case of mutual fund shares, etc., that only the certificate that they are having, but nobody knows that when these particular mutual funds were purchased or which these shares were purchased, they are not in a demat form, in a physical format, and ultimately these are lying idle so far as the things are concerned. That is the reason why risk of identity theft may take place in social media. That is another reason that why we need to prepare a will. Then multiple legal heirs may create problems. So you are aware that when the family comprises of multiple legal heirs, three sons, two daughters, one son, one daughter, two daughters, three sons, something of that sort, then many complications and doubt arises. I will give you one example, and ultimately you will need that why the tussle start so far as the matter is being concerned. There was a lady in Pune, a multimillionaire lady. She died without making a will, but keeping sizable gold and diamond ornaments behind her. She had two daughter-in-laws. The deceased had all types of gold and silver and diamond ornaments, but all of them were only for herself, that is in a singular numbers. She had an excellent costly diamond necklace too. In absence of will, both the daughter-in-laws staked and lodged their claim on it, and finally the matter reached to a court of justice. Finally, court heard the dispute and ordered sale of that particular beautiful diamond legs. And ultimately, the proceeds were allowed to be shared by both daughter-in-law. So none of the daughter-in-law could get that diamond necklace, and ultimately what they got was the money form equally 50-50%. The legal battle lasted for about 9 years, and in these 9 years, the family lost the touch of love and affection which otherwise could have been avoided had a valid will been drafted by the deceased lady. So this is the disadvantage that they ultimately got it. Ultimately, they didn't receive any property which normally they could have had inherited had there been a will. Then the sixth important point why will is being required to be prepared is the consequences of intestate succession are to be avoided. Now you are aware that Hindus are governed under the Hindu Succession Act and other than Hindus the Indian Succession Act. Now when a person dies without making a will, which is called as an intestate succession, then the property will be transferred to the legal heirs not on the basis of the wishes of the person who died, but as per the provisions which have been incorporated in the Hindu Succession Act. So that is the reason why if you wish to avoid that particular succession part, which the Hindu law ultimately Succession Act has made it out, then you have no other alternative but to prepare a valid will. Now, when a Hindu male person dies without making a will, then the person would be said to have died intestate and the property would devolve upon the legal heirs as per class 1 category, then to class 2 category, then to agnates, then to cognates, and finally to the escheat to the government of India under the provisions of Hindu Succession Act 1957, which the concerned person have to accept despite the wishes of the owners in itself. So Hindu male needs to understand if the will is not made, who is going to get his property after his death, which is as under. These are the points which I am just making out. That class 1 heir comprises of widow, son, daughter, mother, son of a predeceased son, widow of a predeceased son, and so on. Around 12 legal heirs are there, and all these legal heirs get the property rights per capita on the basis of number of heads. For example, if two sons are there, each son will get equal. If two daughters or three daughters are there, they will get equal. So accordingly, how many heads are there in class 1? On the basis of that, if there are 15 heads are there, then each one will get 1/5 of the 1/15th of the property in itself. Note one point, all major legal heirs are incorporated in class 1 category, but father is not included. Why he has not been included? We need to ask this question to the drafters of the Hindu Succession Act in itself. When you can incorporate mother, there is no reason why you should exclude the father in itself. And that is the reason why father should have been incorporated in this particular category, which has not been done. So maybe the reason that the mother is more closely related by blood to the son or daughter, and that is the reason why only mother is incorporated in class 1, father is not included. In class 2 category, there are about 10, 15 legal heirs are there, and the father is standing in number 1 in class 2 category. If no class 1 category legal heirs are there, then the property comes to the class 2 category. If class 1 legal heirs, even if one is there, then the property won't come to class 2 category. So this is what the sequence that we have to follow it out. Class 1 category will get on the basis of per capita, and for others in the same category per stirpis on the branch level. But in class 2 category, the principle that you have to learn it out, that the person appearing in the earlier entry will supersede the latter entries in itself. For example, if father is there, he will take entire thing, other legal heirs will not get anything. Or else father is not there, son's daughter, son is there. Yes, if son's daughter, son is there, which is appearing in category 2 in itself, then in that case, he will surpass all other subsequent legal heir. That is class 2 category, which we need to understand. So the sequence is like this. Class 1 category will take on the basis of per capita, whereas class 2 here will get on the basis of sequence, with the earlier entry will supersede the later beneficiaries in itself. So class 1 heirs take simultaneously to the execution of all other heirs, mother, son, daughter, widow get share per capita basis, other get per stirpis basis. In class 2 category, here the heirs, the first entry shall be preferred to those in the second entry and so on. So this is what I already spoke it out just now. if the deceased person has a second wife, if the deceased person has a second wife, legally wedded after the first wife's divorce or death, she will also be considered as a legal heir. I repeat, if the deceased person has a second wife, legally wedded after the first wife divorce or death, she will also be considered as a legal heir. Her children, her children means children from the same deceased person, and the first wife children will also be regarded as legal heirs of the deceased. Children born out of wedlock are also legal heirs, which we need to understand. Then exemptions are there, which we need to make it out. If a property is regulated under the Indian Succession Act 1925 or the Special Marriage Act is exempted under this act, then additionally stepchildren, either male or female, do not have rights to the parent's property. So these are excluded. Also, those belonging to the scheduled tribes do not come under the purview of Hindu Succession Act 1956. Then this is in case of male dying. Now this is in case of female. Hardly 5 entries are there. If the female dies, then the property goes to the husband and children. Then if they are not there, to the husband's heir, then to the mother, then to the father's heir, and to the mother's heir. So this sequence you have to understand and remember, and that creates the difficulty if this sequence is not being known. Then realize that we have seen now why will is to be drafted. But ultimately, we need to make it out what is the importance of having a valid will. Now, there are 4 or 5 points again which we need to make it out. That once the will is being prepared, it avoids unnecessary family feuds and litigation. Because everything one is clear about that, what the intention of the testator is there and how the property is required to be devolved upon the legal heirs. So the importance of writing a valid will cannot be undermined. The presence of a will not only makes estate planning efficient and effective, but also enables the family members of the deceased to avoid unnecessary family feuds and litigation. Moreover, it helps to secure the interest of the legal heirs of the deceased from any relatives or claimants who may arise post the death of the deceased to claim their share. Then second important point, clear differentiation of the nominee from the beneficiary. Now there are two important points which we need to make it out. One is the nominee and the second is beneficiary. What is the difference in between the word nominee and beneficiary? Let us try to understand, which ultimately will give the importance of a valid will. The most important purpose that a will serves is the differentiation of the nominee from the beneficiary. A nominee is that individual who holds the property before its final allocation as per the lines of the will drawn, while the beneficiary is the one who receives the property ultimately. A will helps the testator to efficiently allocate a nominee for the distribution of properties as per the will. So, point to be noted here is that whenever there is a name which appears, which is different from the name that appears in the will, so beneficiary is different so far as the name of the nominee in the category is concerned. So, in other words, nominee is different and the person ultimately who is going to get the property in the will is beneficiary is different. In that particular case, the question that comes into play is that which name will prevail. Is it the beneficiary's name that will be prevailing or it is the nominee's name that will be prevailing? So here the Supreme Court has ultimately laid down and settled the law once for all, and that is the reason why the nominee will be a person who will be holding the property in trust and who is expected to hand over the property to the ultimate legal heirs. So nomination only serves the purpose of transferring the property from one person to another in itself hassle free, and as a result of which the legal heir or the beneficiary will have to get the amount transferred to the legal heirs of the concerned deceased person, whereas beneficiary is the legal heir and is entitled to receive the property as per the provisions which have been made in the will, and will has the backing of Indian Succession Act 1925. A will help the testator efficiently to allocate the nominee for the distribution of property as per the will. Coming to the third important point, so far as the importance is concerned, planning guardians for minor children or dependents is possible with the help of will. One of the major benefits of a will is that it helps to plan out funds and guardians for minor children or dependents after the death of the testator is concerned. In absence of a will, it becomes the sole discretion of the courts to allocate funds and appoint guardians in case of unfortunate death of parents. So, who will be the guardian in case of certain categories when no guardian has been appointed under a will in itself? Then that becomes the mercy so far as the other guardians are concerned. They may treat the legal heirs good, bad, as the case may be. They may not be in confidence or may not fall into the confidence of the testator in itself. So some undesired person also may come into picture in itself. However, using a will, parents or single parent can appoint guardians and allocate funds for their children's future and education. So that is how will comes into picture. You know that this is the important feature of the will. You can appoint a guardian for looking after the minor children and or their dependents and take care of them of money as well as their education and the future of the children in itself. Then the fourth important point, it helps to appoint executors to manage the social media presence. In the present day, where digital presence is a major source of revenue for social media personalities, a will helps to appoint executors to manage the social media presence of the deceased after their death and govern the revenue generated from that particular source. So, this continuity of earning source of income can be ensured by drafting a will and appointing an executor to the will is being concerned. Then there are certain benefits which we need to identify. This was the importance that what we have seen. And now the benefits of the will in itself we will look into. The will ensures your wishes are honored. A will can confirm that testator's belongings are allocated according to his wishes. If you pass away without leaving a will, the state will decide how your estate is dispersed. The precise proportion is specified by the property's worth as per the state. The only method to guarantee that your wishes are carried out is to have a valid will, and that is the wishes to be brought into fruition in itself will be required. Then the second important point I just mentioned about choice of legal guardian. So if you don't choose the legal guardian in itself, it is the court ultimately decide who will be the legal guardian, and your enemy also can perhaps may jump into picture as a legal guardian. So your legal guardian is the individual in terms of handing over your property. If you don't name someone in your will, the law will do it for you. This individual is in charge of the clearing of your debts, terminating your account, deactivating your bank cards, and dividing your estate in either case. So this is the second important benefit that you get. Then selection of trustworthy executor. The initial thing that we saw was guardian, and now this is the case of an executor. With a will, you can choose who will manage and supervise the allocation of your property by writing a will. Choosing a trustworthy and unbiased executor gives you the peace of mind that your wishes will be carried out. Then the next one is maximization of inheritance tax. The sum of legacy tax payable by the descendants after your demise may be reduced if your will is carefully drafted. Then, if both parents die at the same time, in this situation, the will functions as the formal guide for the custody of the minor children. Will relieve stress for family members and guarantees that your body is cared for a testator intent, including funeral arrangements. Setting a property with a will is faster. In most cases, setting a property with written will is faster and less expensive. Estate planning is a major goal. There is a general apathy towards estate planning. Most individuals do not think that they need to write a will. If one wants to asset to go to the people he desires, it is better to write a will. Another challenge in estate planning is to write a will that won't be contested. Video recording of the will writing process comes into picture when one wants to ensure that the will should go unchallenged. So section 59. Now who can make a will? These are the important that what we have seen. Now let us go into the details and find out who can prepare a will, who can make a will, and who is capable of making a will. Section 59 of the Indian Succession Act specifies that who can make a will and provide that every person who is a person of sound mind, who is not a minor, can dispose of his property by will, and a married woman can dispose of by will any property by which she could alienate by her own act during her lifetime. So, two important conditions are there. The person should not be minor, and the person should be of a sound mind. Who is a minor? A person will be deemed to be a minor if he is below 18 years of age. To be more precise, under Indian Majority Act, it has been specified that a person will be said to be major once he reaches the age of 18 years. And if the administration of the state is vested with the courts of war, then the age of completion of 21 years of age. So, unless the administration of the state is with the courts of war, then the person will be said to be minor till the completion of 21 years. Otherwise, it is 18 years. So he should not be below 18 years or 21 years is the major issue. And the sound mind is the major issue which we need to make it out. Then a person who is deaf and dumb and blind can make a will if they are able to understand what they do by it. So if they are drafting a will, they are doing something, they need to understand the implications of what they are doing. And if they know the impact analysis of that, then only they can prepare a will, otherwise not. A person who is ordinarily insane may make a will during interval during which he is of a person of sound mind. So this is the case that when the person is normally a person of unsound mind, but occasionally becomes a person of sound mind, law says that he can still make a will when the person occasionally is of a sound mind. Conversely, if a person is ordinarily sane, he cannot make a will when he is not of a unsound, is not of sound mind, as and when he is under influence of drugs or is intoxicated. So if the person is influenced by drugs and intoxicated, then he cannot make a will. However, no person can make a will while he is in a such state of mind that he does not know what he is doing. Even though the person is of a sound mind, but is not in a position to understand and find out the implication, he cannot make a will. The Calcutta High Court has observed that mere ability to sign his name or carry on ordinary conversation and answer familiar and easy questions does not necessarily constitute a sound and disposing mind. It is quite well settled that a will made by a person who is drunk or so much under influence of an intoxicant that he is deprived of his mental faculty or reason and understanding will be treated as void of no effect. However, a will cannot be challenged only on the ground that the maker was a habitual drunkard, unless it is proved that at the time of executing the will, he was under an influence of liquor. So you cannot rule out a person, that person who consumes liquor every day he is an habitual drunkard in itself. And for that reason, you cannot say that the will is wrong in itself. That will not be the case when the person, only that cannot be a ground. Mere old age does not disqualify a person from making a will. Whether the person had sufficient mental ability to understand the nature of his testamentary act needs to be ascertained. But this can be done only by the medical practitioners, for which the certificate is required to be attached. Merely because of old age has made his memory rather feeble is no ground for nullifying his will in itself. However, in cases where wills are made by old, sick, or dying person, it is not enough to show that such a person was able to answer usual or familiar questions. It is also necessary to prove that he was fully able to comprehend the nature of his testamentary act and that he understood all aspects of the will when he executes it. It has been held that a will is not invalid only because the testator made it just before committing the suicide, provided that He was otherwise mentally fit when he executed the will. The testator was given an injection and a blood transfusion before the execution of his will does not by itself invalidate the will if the testator was otherwise capable of making a valid will. As long as the provisions of the act are fulfilled, a person can give away his entire property by will is the rule of law. If there is a residuary clause in a will, this is more important, all property not given in specific legatee under the will would fall within the residuary clause and go to the residuary legatee. So this is what the major thing that we will have to look into. Then in a case, there are certain illustration I am just making out. In a case decided by the Supreme Court, a will was made by a Hindu widow who was 70 years old. By this will, she bequeathed all her property in favor of her brother's grandson, in whom she reposed full confidence. The factum and the validity of this will were challenged by the sons of her husband's brother, who alleged that suspicious circumstances surrounded the will and it was therefore not a will. It was proved before the court that the testatrix, that is the lady making the will, the old Hindu widow in the present case, was of sound disposing mind, although physically incapable of signing her name at the time of execution of the will. Taking all the facts into consideration, the court held that the will to be valid as the suspicious circumstances were not proved. This happened in Brijmohan Lal Arora case versus Girdhari Lal Manucha, AIR 1978, Supreme Court 1202. Then another instance can be Gotu can perceive, Gotu is the name of the boy, Gotu can perceive what is going on in his immediate neighborhood and can answer familiar question, but has no competent understanding to know the nature of his property or the persons who are of kindred to him, or in his whose favor it would be proper that he should transfer. He cannot make a will. So he is not understanding the basic issues in itself, and that is the reason why he cannot make a will. And he executes an instrument purporting to be his will, but he does not understand the nature of the instrument nor the effect of its provision. The instrument is not a valid will. Chandragupta, being a very feeble and deliberated, is capable of exercising a judgment as to the proper mode of disposing of his property. He makes a will. This is a valid will. Now, important elements, the ingredients of a will, which you need to see in the drafting of the will, which are the intricacies which we need to understand. And these are the ingredients of a valid will. What are the basic features which you ought to have in drafting the will? The first is it's a legal declaration. Will is a legal declaration because A, it has been made in conformity with the provisions of Section 63 of the Indian Succession Act to ensure its proper execution and attestation as laid down. It has been made by a person competent to make it. The declaration should relate to property of the testator which he wants to dispose of. So this third point is also important because the property must belong to the testator. Otherwise, if he wants to sell it off Shaniwar Wada or Taj Mahal, that will not be of any help because they should be the person, deceased person or testator should be the owner of the property. A major person is legally competent to make a will, and by will, a minor is not a declaration. It may also be noted that the mere use of the word will cannot make it a will if it does not amount to testamentary declaration or disposing of the will. So if you have prepared a will and you just jotted down some document has been prepared and you write down that it is a will, that will not become a will unless the ingredients are being satisfied. If the declaration contains no reference to the disposal of the property, but merely appoints a manager to manage the property or gives merely an authority to his widow to adopt, it is not a will. So this is major important point which you need to understand and make it a prominent in drafting the will, that the will must contain disposal of the property. disposal of the property is the crux of the will in itself. And if it is not there, it will not be a will in itself. Though you have appointed a manager for looking after the property, or you have appointed your widow itself as to adopt the property in itself. In one case, a document was executed by a Hindu of advanced age. In this document, he partitioned his property amongst his son, and the document was labeled as will. Amongst other, his so-called will contained the following clause. If I at any time come back from pilgrimage and find mismanagement or character of any one bad act, then I shall have the power to cancel this will. It was held that the effect of this clause was to make the document a family arrangement and not a will. And that is the reason why this was not considered as a will. This was decided in Ramnath versus Ram Nagina in itself. Then the second important ingredient of the will is transfer intended to take place after death. So the property cannot be transferred during the lifetime of the testator. It has to get it transferred only after the death of the testator in itself. The declaration as regard the disposal of the property of the testator must be intended to take effect after the death of the testator. There has to have some specific clause to that effect in the will. So this is the fundamental part that we need to incorporate in the will. If this clause is not there, then the will not be technically called as a will. That the entire property will be transferred to the legal beneficiaries only after the death of the testator. This clause, this specific clause to that effect is required to be present in the will in itself. If the declaration is not to that effect, if the declaration seeks to effectuate the intention of the writer immediately during his lifetime, then it is not a will. Please keep this particular point in mind. A will written on a simple page of paper also derives legal value being a will. So it is not necessary that it must be on a stamp paper, non-judicial stamp paper, then ledger paper, that is green paper, or a properly drafted, properly printed, properly jotted down will in itself. Even a piece of paper which has been jotted your desires over there in itself, keeping ingredients of will in mind in itself, will be a valid will in the provisions of law. Then the third important feature of the will is, the ingredients of the will is, it is capable of being revoked. The essence of every will is that it is revocable during the lifetime of the testator. A will always operate from the date of testator's death and not from the date of execution. So keep this particular point in mind, that the other words I can say that will start speaking from the death of the testator. Till that time, it is not capable of speaking. So speaking starts on the date of death in itself and not from the date of execution. A will is revocable instrument as distinguished from deed. Deed is different and will is different. Deed is not capable of being revoked in general cases, whereas will is capable of being revoked. A will of a living person does not come into operation when it is executed, but only upon his death. So only the will can be executed once the person die. Otherwise, question of executing it does not arise is the third important element which we need to make it up. A will is in its nature ambulatory during the maker's lifetime and therefore always revocable so long as the testator is living. The only instance in which will cannot be revoked is in the case of mutual or joint wills, which later on we'll see the different definition of mutual and joint wills. Mutual wills is that the properties are being given to each other, and joint wills like husband and wife, they are making the wills. Those are not capable of being revoked after the death of one of the makers itself. Revocation means technically official cancellation of a decision. Technically, according to section 62 of the Act, a will is liable to be revoked, altered by the maker of it at any time when it is competent to dispose of his property by will. The testator's right to revoke during his lifetime is always absolute. it can neither be waived nor restricted. So you cannot draft it the way in which it is required to be carried out. Revocation of unprivileged will can be done by two ways. Now, there are two ways how this unprivileged will can be revoked. One, the revocation by operation of law. According to Section 69 of the Indian Succession Act, every will shall be revoked by marriage of the maker. The maker can be a man or a woman. This is a revocation by operation of law. The principle upon which the will is revoked by marriage is that marriage creates such a change in the testator's condition with new obligations and duties, and that is the reason why it is being revoked. They raise an inference that the testator would not adhere to the will made before marriage. Every will, whether unprivileged or privileged, is revoked by marriage of the maker. Now, there are exceptions also. Property bequeathed by the executor who is empowered to do so. Second, when two persons make mutual wills, the marriage of one of them does not revoke the will of the other. Section 69 does not apply to Hindus. A will made by a Hindu is not revoked by his marriage. So these are the point A, and B is also there. Revocation by the act of party. First was operation of law, and this is act of party. That was section 69. This is section 70. According to section 70 of the act, no unprivileged will or codicil nor any part thereof can be revoked by preparing another will or codicil, by some writing declaring an intention to revoke, by burning, tearing, otherwise destroying the same by the testator, or by some person in his presence and by his discretion with the intention of revoking the same. So I'll give some illustration so that this can specify this particular point. Ram has made an unprivileged will. Afterwards, Ram makes another unprivileged will which purport to revoke the first. This is will second has not mentioned about the revocation of earlier will. The legal effect will be that the earlier will stands automatically revoked. Sham has made unprivileged will. Afterwards, Sham has been entitled to make privileged will, makes a privileged will which purports to revoke his unprivileged will. This is also called as revocation. Then the fourth important, more important and valuable point is about stamp duty and registration part, whether will requires registration and stamp duty. No stamp duty is payable on documents of wills and codicils. This is very, very important point which everybody needs to understand, that no stamp duty is payable on the registration or doing that wills and codicils are concerned. Hence, wills and codicils need not be written on non-judicial stamp papers. So as I already made it out, it can be on a piece of paper. There is a misconception that all legal documents, in order to have legal binding effect, should be written on non-judicial stamp paper of adequate value. However, if the wills are or codicils are written on a plain or simple or a piece of paper, still these documents are valid legal document, is the fourth important major ingredient of a will that we need to understand. The registration fee of the wills and codicil are different across India as it is a state subject. In the state of Maharashtra, the registration fee is only rupees 100 and you can get the will registered in itself. Now, there are advantages of getting the will registered in itself, and major important point that what you need to make it out, that if you prepare a codicil for that in itself, that if the original will is registered, then the codicil also is required to be registered. You cannot say that the will was registered, but the codicil is now not registered. So both are, if earlier is not registered, the second may not be registered. But if the earlier is registered, the second codicil also is required to be registered. Then coming to the fifth important point, that when a will is being prepared, that will is required to be witnessed by at least two major witnesses in itself. A will is a legal document that outlines the distribution of a person's property and assets after their death. The process of creating a will is governed by the Indian Succession Act 1925. One important aspect of creating a will is the role of witnesses. And that is the area where I am inviting your attention on now. A witness is a person who observes the signing of a will. I am highlighting this particular word, signing of a will. That when a person is to be called as witness, what is the role of witness? Witness has to see that the testator is signing the will in itself and attest its validity in itself. The person who ultimately is signing is the testator, is the major issue that they ultimately have to find out. In India, two witnesses are required for a will to be considered a legally valid will. So, important feature in case of ingredient of a will, so far as witnesses are concerned, the witnesses are required to observe that the testator is signing the will. He needs to observe that will is being signed, and that is the major issue that they need to consider so far as the things are concerned. These witnesses must be present at the time of signing and should not be beneficiaries of the will. So keep this particular point in mind again, that the persons who are witnesses should not be beneficiaries in itself. So if the person is beneficiary, then he cannot be a witness in itself. The legal hair will not be there. That is the major issue that you will have to look into. The role of witnesses is crucial in ensuring the validity of a will. They are responsible for verifying the identity of the person creating the will, confirming that the person is of sound mind, understand the contents of the will. So why and what for the witnesses are responsible? They are responsible for identifying the identity of the person, confirming that the person is of a sound mind and understand the contents of the will in itself. So this is what the major issue that they need to identify so far as the things are concerned. The witnesses are also to ensure that the will is signed voluntarily and without any coercion. So somebody should not be there behind the person who is making them to ultimately forcing the concerned testator to sign. They need to understand and observe. Additionally, witnesses play a vital role in case of any legal dispute that may arise after the death of the concerned person. If the validity of the will is challenged, witnesses can be called upon to testify and provide evidence about the signing of the will. So one major issue of witnesses is that they are expected to testify if there need be. It is important to note that witnesses must be competent to testify in the courts of law. This means that they must be of legal age, must not have been declared mentally unsound or disqualified from giving evidence in the court. In India, it is recommended to have witnesses who are not related to the person creating the will. So it is expected to observe that the witnesses which you are choosing out should not be your relatives in itself. Even the distant relative is to be ruled out so far as the things are concerned. This is to avoid any conflict of interest that may arise due to relationship with the person. Witnesses should also be individuals who are likely to outlive the persons creating the will. So this should not be of a senior age. Otherwise, the witnesses will die first and then the testator will die. That shouldn't happen. And that is the reason why the age of the witnesses should be of a comparatively younger age so that they can be available to testify if there need be. In short, the will must be attested by at least two witnesses as under now. Each witness must have seen the testator sign or affix his mark, left hand thumb impression, or seen some other person sign the will in the testator's presence under his directions. Each witness must have received the testator a personal acknowledgement of his signature, which is the basic condition which every witness is expected to observe. That what he is expected to get, that testator's personal acknowledgement of his signature. Thank you for signing the document in itself as a witness, something of that sort, or of a signature of such other person. Each witness must sign the will in the presence of the testator, although they need not sign in the presence of each other. Beneficiary, that is legatee or its spouse, shall never be the witness to the will in itself. So this is what the Supreme Court has ultimately jotted down. Ordinarily, wills are signed by the testator himself. However, testator may, instead of signing the will, put his mark, thumb impression thereon, either because he is illiterate or because he is incapable of signing on account of weakness or fractured finger, for instance, or even through sheer habit. Now, why will is needs to be witnessed? That is the major issue we will have to look into. Will is an essential document in which testator make critical decisions about whom he wants to receive his property and care for his minor children after he is no more. So this is the need by which it is required to be witnessed. Since will goes into effect after testator passes away, he is no longer around to confirm it truly belongs to him. And that is where the witnesses come in. They had watched testator signing the will and can confirm in front of a court that the document is authentic. Now, who can witness the will in itself? Can anyone be a witness to the will? The short answer will be no. There are some basic requirements for who can witness the will. The witness should be of a legal adult, which means 18 years plus or 21 years as the case may be, as per Indian Majority Act 1875, and of sound mind. So two essential ingredients are there. They should also be disinterested, meaning they aren't related to the testator by blood or marriage, and that they don't stand to inherit anything from his estate in itself. The testator can choose the following people as his witnesses. Chartered accountant can be chosen, friends can be chosen, neighbors can be chosen, co-workers can be chosen, lawyers can be chosen, anyone else trusted, the testator trust also can be chosen. So that is area which we need to make it out so far as the things are concerned. Then coming to the next part, so far as the who shouldn't witness the will in itself, anyone who is listed in testator's will stands to inherit something under will shouldn't be a witness to avoid conflict of interest. This could include spouse or partner, children, grandchildren, anyone listed in the beneficiary in will, and anyone related to them, someone who is likely to pass away before testator, like a parent, a minor, or someone below the age of 18 years. What happens if a will isn't signed by the witnesses? If the will is not witnessed, that means there is no one who has authority to prove that the will is authentic. This could lead to a will being challenged in probate court or being thrown out of completely. If the will is thrown out, then the estate will be distributed according to the provisions of the Hindu Succession Act. Not having the will witnessed would likely to cause delays and confusion for testator's loved ones and may result in his wishes not being followed as he may have intended. Now, the next sixth important point, which is the ingredient of a will, is attestation. A mere signing of a will by another person does not always amount to attestation. Attestation means signing a document for the purpose of testifying the signature of the person executing the document. So, what is attestation? That the very person who is the testator, he has signed in the presence of the witness in itself, then that will be called as an attested signature is being attested. It is not necessary that the witness should know the contents of the will. The witness is not expected to know the contents of the will, but he may read. That is another issue. If the testator allows, then he can read the will. But ultimately, it is not expected that the contents of the will should be made known to the witness in itself. Then there is another person, the executor of a will. The executor is someone who is named in the will to manage the deceased person's estate. The executor is responsible for carrying out the deceased wishes and instructions, including paying of the debts, making funeral arrangements, then including paying of the debts, then distributing assets to the beneficiary. The executor is also known as an administrator. Typically, an executor can be a chartered accountant or a lawyer or a family member. The testator or the person who makes the will can appoint an executor, or court can appoint one, if there is no prior appointment. The executor may need to apply for a special legal authority before they can deal with the estate. Now, what are the duties of the executor? The executor has to meet out the funeral expenses, obtaining death certificate of the testator, interpretation of the will in the right manner, distribution of assets to the correct beneficiary, drawing up inventory of the assets to be sold or to be disposed of, expense management for all the properties until disposal of the same is required to be carried out, applying for probate, payment of money that is due from testator, collecting money due to the testator, settlement of assets as directed in the will, maintaining records of all transactions, representing the testator in any legal action, excluding criminal and defamatory matters. So these are the beneficiaries the executor is expected to do. Now, what advantages the concerned testator will get by appointing an executor? Beneficiaries shall be ensured of all proper handling of the property. By appointing a third person as an executor, the family can be relieved of administrative responsibilities of the executing the will. If the executor is appointed in time, it shall have the time and money and shall prove to be advantageous to the beneficiaries. Many cases have been pending in the courts due to family disputes, which can be avoided by appointing an executor who will be neutral and fair in his dealing. Executor not disqualified from being a witness. In other words, although legatee cannot claim under a will if he or his spouse is a witness to the will, there is no such bar on an executor, and thus the same person may validly be an executor as well as an attesting witness. In such a case, he cannot take a legacy or other benefit under the will. Then medical practitioner certificate is nowadays very important. It is advisable to have a doctor as one of the attesting witnesses, especially in case where the testator is old or infirm or hospitalized or where the will is likely to be challenged after the death of the testator. This is done so that the doctor can testify if there need be that the testator was of a sound mind and understood what he was doing. However, as observed by the Supreme Court, there is no rule of law or evidence which requires a doctor to be present when the will is executed. This was decided in MD Shande versus Tarabai's case in itself. So it is advisable that medical practitioner certificate should be attached along with each and every will. So once the will is being prepared, everything can be sorted out and it cannot be challenged later on. Then the ninth important ingredient of a valid will is the signature of the testator. Either the testator must sign or affix his mark to the will, or the will must be signed by some other person in the testator's presence under his directions. Intention behind signature is the most important and relevant factor. Such signature or mark must be so placed that it appears that it was intended to give effect to the writing as a will. So, two important features by signature you can make it out, that there is an intent to transfer the property and the intention is to give effect to transfer of property. These two important things are there. Now, there are certain guardians which we need to understand. One is the testamentary guardian under section 60 of the Act in itself. To the general rule enunciated in section 59 that the testator must not be a minor, there is only one exception to be found in section 60 of the Act. It lays down that a father, whatever his age may be, can by will appoint a guardian for his minor children. In such cases, the father's age is immaterial. If a minor father is there, can he appoint a guardian for his minor children was the issue. And it has been clarified that except only in one case, that what has been pointed out just now, a minor father can appoint a guardian for their minor children. Today, however, the child marriages are restrained under Child Marriage Restraint Act of 1978, which prohibits the marriage. But once the marriage is performed, then that is not illegal. It is it is legal marriage so far as the things are concerned. Now that is the reason why Child marriages are not illegal, but they are not permitted. So it is a deterrent action, rather preventive action, rather than a creative action, so far as the things are concerned. Then coming to the 10th important point, that ingredients of a valid will is the registration process. Under Indian Registration Act 1908, there are few documents that have got to be registered compulsorily has been specified in section 17 of the Act. So in short, which documents are required to be registered under Indian Registration Act have been specified in section 17 of the Indian Registration Act. However, the registration of a will is not incorporated in section 17 of the Act. So under section 18 of the Registration Act now, it is provided that registration of a will is not mandatory or compulsory. However, it is advisable to register the same as it has more evidentiary value in the courts of law. Now, in the case of Ishwar Dev Narayan Singh versus Kamata Devi and others, AIR 1954, it was held by the Supreme Court that non-registration of a will cannot be held as a reason for the invalidity of the will is concerned. So if it is not registered, the will never be called as invalid. Thus, it can be concluded from the above precedent that it is not mandatory for anyone to register a will, or it cannot be said that it will be invalid just on the ground that it has not been registered. In the case of Raj Kishore Panda versus Banitra Madhya Engineering Vidyapit, the will was put forth as one of the documents under Section 18 of the Registration Act, and for which registration was only optional. In the case of Raili Rameshwari Bendapudi Surya Prakash Rao, AR 1962, no advance presumption could be drawn if the will is not registered. So in both these cases, the wills were not registered, but the decision did not went against the testator. It was also suggested that the non-registration of the will was very material circumstance against its truth, and the explanation offered for non-registration was palpably false. So in that case, the reverse decision would be there. No technical words, 11 point language and writing of a will. No technical words need to be used in a will, and a will can be in a very simple language and in any language. India has got so many thousands of language, you can write the will in any language. There is no bar on that. However, the words used should be clear and unambiguous so that the mind of the testator is reflected in such words with sufficient clarity. It is not really important whether a will is typed or is Word document or a handwritten, and if the latter, whether it is written in ink or in pencil, whatever the case may be. However, now certain English courts have held that if a will is written in ink and the testator has made pencil alteration therein, it will be presumed that the alterations were deliberately made. Technically, making a will should be very simple, affordable, hassle-free, and safe against litigation to distribute a person's asset and property among legal heirs after his lifetime. As per Indian law, a will, irrespective of whether it is handwritten, typewritten, or on plain paper in a clear language and witnessed by at least two persons, is totally valid in itself in legal terms. Registering a will by visiting courts of law or getting a notary to attest it is simply optional, not mandatory. Creating a will should be straightforward activity, and it is not a rocket science. Yet many will makers make silly mistakes while writing the will in itself. With a bit of counsel, they can always easily avoid these follies. The biggest folly is not caring about drafting your own will at all. These are the points which we need to note. The 12th important point is about the patent and latent ambiguities. An ambiguity is of two kinds. One is a patent ambiguity and the second is latent ambiguity. Patent ambiguity is one which is clear on the very face of the document. Thus, Shankar says in his will, I give 2000 to Timber. To there is a blank space here. No legate is mentioned. this ambiguity is visible on the face of the document. It is the instance of legal patent ambiguity, which is dealt with by Section 81 of the Act in itself. So when it is evident that name is not specified, blank space are there, in that particular case, it will be a patent ambiguity under Section 81. If there is any patent ambiguity, one visible on the face of the will, extrinsic evidence is not admissible to show what intention of the testator was there. And this is the crux of this patent ambiguity. No outside evidence can be brought in to specify that some other name was there, A was there, B was there, C was there, etc. This is blank means blank, nothing can be done about that. If the testator has kept his will incomplete, evidence can never be given in order to complete it or add it or explain the incomplete portion. Thus, the legacy does not take effect in such cases as per his will. Example again, a man has an aunt Sita and a cousin Gita and no aunt in the name of Gita. I will repeat, a man has an aunt Sita and a cousin Gita and no aunt in the name of Gita. But by his will, he bequeaths 1,000 to my aunt Sita and 1,000 to my cousin Gita, and afterward bequeaths 2,000 rupees my before mentioned aunt Gita. There is no person to whom description given in the will can apply, and evidence is not admissible to show who was meant by my before mentioned aunt Gita. The bequest is therefore void for uncertainty under Section 89 of the Act. Shankar bequeaths to Rajesh so and so rupees or my estate of so and so rupees. Evidence is not admissible to show what sum, what estate the testator intended to insert. So this is what the patent ambiguity is all about. Now, latent ambiguity, on the other hand, is one in which words are used which, though unambiguous, are capable of being construed one way or the other way. Section 80 deals with this type of ambiguity. The general rule is that oral evidence of the testator's intervention is not admissible unless there is a latent ambiguity. For example, to explain nickname, if the ambiguity is latent, that is, the words are used unambiguous, extrinsics outside, evidence can be accepted by the court to clear the picture in itself. Example, a man having two cousins of the name of Sita bequeaths a sum of money to my cousin Sita. It appears that there are two persons, each answering the description of the will. That description therefore admits two applications, that is, meaning only one of which have to be given intended by the testator. Evidence is admissible to show which of the two applications was intended. Ram by his will leaves to Love and Kush, my estate called Ayodhya Budruk land. It turns out that he had two estates called Ayodhya Budruk land. The evidence is admissible to show which estate was intended. So that is how the latent ambiguity that ultimately talks about. Then the 13th ingredient of a will is inconsistent clauses. Sometimes a will contains inconsistent clauses. The following three rules are required to be followed in such a case. Now these three rules are like this. 1. Every will has to be read as a whole, and meaning is to be gathered from the whole instrument and not by disjoint reading of the various clauses. The true intention of the testator has to be gathered not from the isolated expressions in the will, but by reading the will as a whole. For example, where a testator is having an estate, bequeaths the whole estate to Yash, and in another part of his will bequeaths one part of his, which called Golibar Maidan, to Vijay. The latter bequest is to be read as an exception out of the first, as if he had said, I give Golibar Maidan to Vijay and the rest of my estate to Yash. Where the clause is susceptible to two meanings, one having the effect and the other none, the former is to be preferred under Section 84. But no part of the will is rejected if a reasonable construction can be put upon it under Section 85. An attempt is to be made to reconcile the apparent inconsistencies and contradictions in a will. However, if that is not feasible, the general intention of the testator should be given effect too, even if it involves rejection or transposition of particular superfluous or even misplaced word. Where two clauses of gifts in a will are not capable of being reconciled, as they cannot possibly stand together, it is last clause that will prevail. For example, the testator by the first clause of his will leaves his estate at Pune to Riddhi, and by the last clause of it leaves the Siddhi and not to Riddhi, gives to Siddhi and not to Riddhi. The estate will go to Siddhi. If a man at the commencement of his will gives his house to Raj, and all the clause of it direct that his house shall be sold and proceeds invested for the benefit of such, the latter disposition will prevail. So the property will have to be disposed of. Item number 14 for ingredients. Form of a will. There is no prescribed form of a will. It needs to be only properly signed and attested as required by the Indian Succession Act. The intention of the writer to convey the benefits by the instrument which would be conveyed by it, if considered as a will, provided the writer had the necessary intention or animus testandi. A will, though formally executed as such, will not be valid if there is no animus testandi, that is, it was written in jest or in a hurry. If the necessary animus testandi is present, even agreements later, bills of exchange, powers of attorney may operate to take effect as wills, provided that under such animus testandi, the dispositions are not to take effect until after the person's death. Point number 15, ingredients of a will, residuary legatee. A residuary legatee is one to whom the testator gives the surplus or residue of his property after the legacies and bequests are made. A residuary legatee is constituted by any words of the testator showing an intention that the person designated by him shall take the surplus or residue of his property. For example, Kangana makes her will consisting of her several testamentary papers, in one on which contained the following following words. I think there will be something left after all funeral expenses, etc., to give to Akshay, now at school, towards equipping him to any profession he may hereafter be appointed to. Akshay is constituted the residuary legatee. So, in short, the point we need to make it out would be that whatever property is required to be distributed, once it is distributed, but there is a residuary clause that in case some property which is not mentioned above, if it has been found out for which no legal has been specified, the property will go to the residuary legatee. That is what the major thing which we need to find out. A Nero makes his will with the following passage at the end of it. I believe there will be sufficient funds in my banker's hand to defray or discharge my debts, which I hereby desire Harshala to do and keep the residue for her own use and pleasure. Harshala is constituted to be residuary legatee. Amarnath bequeaths all his property to Balwinder except certain stocks and funds, which he bequeaths to Kalicharan. Balwinder is the residuary legatee. Point number 16 in ingredients of a will is codicil. A codicil means an instrument made in relation to a will and explaining, altering, or adding to its disposition and shall be deemed to be part of a will. Section 2 small b of the Indian Succession Act says a codicil is a legal document that modifies earlier will either in part or in whole. It can add, remove, change provisions in the will, but it does not replace the will itself. Codicils are typically used when someone wants to make small changes to their will rather than creating a new one. A codicil must be executed with the same formalities as the will itself, and it must be signed witnessed in the same way. The will maker must sign and witnesses must be present. The codicil is then attached to the copy of the original will. A codicil can be used to change executor, update beneficiaries, update guardianship wishes, protect beneficiaries from tax consequences, and revise end of life wishes. Then the 17th important point of ingredients of a valid will. Can a will be challenged after death in India? The answer is yes. A will is a formal statement of testator's intention regarding both his movable and immovable property. A will can only be carried out after the testator has passed away if the testator's assets are distributed before to his passing. The document is not a will. The validity of will after death may also be contested in court, but only within the limited time frame. Therefore, continued validity of will is of a crucial importance. Can a will be challenged after death? The terms of a will must be followed after the testator's demise, since the main purpose of the will is to carry out testator's wishes about his properties and other assets. A will's validity may be disputed even after the testator has passed away. To put it simply, a will is valid whether it is registered or unregistered. There is no time limit on when the will goes into effect. For a period up to 12 years after testator's demise, a will may be challenged. According to the Supreme Court's ruling in Jamna Das versus Naveen Thakral and others, the civil judge may waive the 12 years deadline if there are valid reasons why some parties may not have known about the will for a lengthy period of time. However, this could be however However, this could be compromised to natural justice. How long a will is effective? A will is still valid and enforceable even after the testator's death. However, there is only 12-year window in which the will can be contested, and if someone wants to do after that time, they must provide justification. The will is deemed to be executed if its provisions have been carried out. Indian law does not have the particular provisions governing the longevity or duration of the will. The term permanent will refers to a will that has been in effect for 12 years or more. In conclusion, there is no temporal limit on the duration of will's validity because it is valid for the beneficiary's whole lifetime and is always enforceable. Now, let us go back. This was pertaining to the self-acquired property. Now, let us go into the details about the ancestral property, whether you can make a will therefore or not. The person who makes the will is called as a testator, which I already told. A testator can only dispose of by will property over which they have absolute ownership. This is also called as self-acquired property. Recently, the Supreme Court clarified an important point on the law of inheritance of the property, whether a person can bequeath their self-acquired property to any person, and it includes property purchased by the testator through their income or personal resources. Property received by the testator through a gift deed, inherited through a will, and ancestral property received by the testator as their share after partition. For example, partition of the Hindu undivided family. Self-acquired property can be willed away to the testator's heir and just one legal heir, excluding all others, or even to a stranger non-heir, since the testator has absolute ownership over such property. A person with a share in ancestral property, that is, property that has remained undivided over 4 generations, acquired at the time of birth, for example, co-partner in the HUF, does not have absolute ownership over the whole share of the property. Therefore, they cannot give the entire ancestral property by will to their heirs or to a stranger. According to the Indian National Bar Association, property inherited through a will is not considered as ancestral property. Ancestral property is passed down through generations within the family and is collectively owned by the family. Once partitioned, it becomes self-acquired property and can be willed to anyone. However, under the Hindu Succession Amendment Act 2005, state that all legal heirs have an equal right to ancestral property based on birth. This includes women as well, who are considered co-partners and have the same rights as that of sons. If the property is legally divided among the family, each heir share becomes self-acquired property and can be willed. If someone dies without a will, their class 1 legal heirs will have the property rights in itself. So this is what the major thing that I just wanted to share with all of you so far as the technicalities were being concerned. So some other aspects are also there which I would like to share with you in itself, so far as the examples are concerned. If any person inherits the property that we have already discussed. Now, will of the ancestral property is not entirely illegal. That is what the decisions are being talked about. It means that when a co-partner acquires his share in ancestral property, then if the co-partner before acquiring share makes a will, then that will be illegal. That is what I have already spelled out. And that is the two cases are there which we need to make it out. That during the course of discussion, question answers, we can have a more focus on that. This is specified in the Mullah's book on itself, Mullah's on Hindu law. Now, a special feature that I wanted to share with all of you, and that was pertaining to the will of the non-resident Indian or uh, non-Indian citizen, OCI, overseas citizen of India. Now, non-resident Indian are having some different background as compared to residents in India. The main question is, can they create a will in India, or they are supposed to prepare a will outside overseas so that the different assets such as immobile properties, mobile properties, bank account balances, shares, mutual fund, bonds, other financial instruments, vehicles, jewelry, and other personal belongings and valuables can be transferred to their legal heirs. If NRI has assets located at more than one country, it would be ideal for them to prepare a will to avoid various conflicts and the difficulties in execution and recognition of the will in view of varied succession laws of the respective country. So point I'm just making out here is that the location of the property will play an important role so far as the will of the non-resident Indian is concerned. If the non-resident now has started living in India but doesn't have any property outside India, then he can prepare a will as per Indian Succession Act or similar other sections which we have discussed. But if he happens to be having the properties in multiple countries in itself, then he will have to prepare multiple wills based on the rules and regulations in the country where the property is being located. So if the person happens to be having properties in 5 countries in itself and India too, so it will have to prepare 6 important wills, which ultimately will be based on the rules and regulations that of the respective country, which we'll have to look into. Now, NRI needs to take account of the following laws when he is preparing a will: Indian Succession Act, then Indian Registration Act, that is the second part, Foreign Exchange Management Act 1999. These are the 3 laws which he need to take into account. It is important to note that a will for Indian assets can be drafted, written by NRI anywhere, either in India or outside, covered elsewhere. Points to be considered while preparing a will where the property is outside India. When NRI is making a will while he is in outside India, a foreign will, it is to be called as a foreign will in itself, then he must comply with the laws of the country where the will is being made drafted. If such foreign will captures in relation to asset based in India, the will may not be automatically enforced in India. So if at all some problems are there in outside India where the property is being located, that will cannot be enforced inside India is the point which I'm just making out. We'll have to go there to get that particular matter enforced. The beneficiary or executor would have to undertake the following actions. 1, the probate will have to carry it out. As indicated, probate is the copy of the will that has been certified through legal process. This process involves determining the authenticity of the will in a court of law. Then for enforcement of a will written abroad, the beneficiary executor would be required to obtain probate from the court and authority of the relevant foreign country in itself. Then authentication is very important. After obtaining the probated copy of the will, you need to authenticate by way of an apostille. Then legal certification that makes document from one country valid for the use of another country or any other manner required by the relevant country. Submission is also important. Such authenticated probate of the will is required to be submitted to the relevant court in India to apply for ancillary probate or letter of administration. In this regard, it is essential that both the countries should be a party to a Hague Convention of October 5, 1961, abolishing requirement of legalization for Foreign Public Document HCCH 1961 Apostille Convention. Now, what are the issues? Now, will is to be prepared, and now we have to identify what are the issues involved. Can NRI who owns two flats in India bequeath the property to his children? One is resident in India and the other is overseas. NRI can bequeath his flats to both the children through a will. There are no restrictions for bequeathing the flat to a child who is resident in India. However, as per prevailing FEMA regulation, if one wants to bequeath the property to a child who is also an NRI or OCI, one can do so provided that the flat acquired in accordance with the foreign exchange law in force at the time of acquisition. If the flats were acquired when NRI was Indian resident and not an NRI, then there are no restrictions under FEMA for bequeathing the property to either of the children. Master direction is already there, which is specified by RBI, which is spelled out over here. How the movable property of an NRI can be divided amongst legal heirs in India. Movable property can include cash, painting, jewelry, electronic devices, vehicles, etc. Current foreign exchange laws do not have any specific provisions or restrictions on the inheritance of the movable assets in India. However, as per the Indian Succession Act 1925, bequeathing of movable assets is governed by the laws of the country domicile at the time of his demise. So that is major important point that we will have to look into. As an NRI, having his domicile in India dies in France, the movable property in France, India and United States of America, the succession to all such movable property will be regulated in accordance with the laws of India. In addition, there could be other requirements of NRI needs to consider when it pertains to movable assets owned in India. For example, based on personal laws. Then that is the Indian law. The third important point which we need to understand would be, does an NRI who owns property in multiple countries need to prepare separate wills for each country? When NRI hold assets in different parts of the world, it is not mandatory to have separate wills, but if he has, it could be helpful. There may be different succession laws applicable to each country, and that is the reason why they need to prepare separate wills to avoid any conflicts. This would help to ensure that the will is recognized in the relevant countries. Can an NRI with resident parents in India inherit immobile property? Yes, as per the prevailing FEMA regulations, an NRI can acquire any immobile property in India by way of inheritance from a person resident in India. Does NRI need to validate will registered abroad India? For the purposes of enforcement of a foreign will registered abroad in India, the foreign will would require to be authenticated by way of obtaining a probate from the concerned competent courts or authority under the relevant foreign country. Subsequently, the probated copy of the foreign will is required to be apostilled and filed before the relevant court in India for grant of letters of administration. Meaning of the word for NRI. It is ruling issued by the competent court upon application by the executor after the testator has passed away, attesting the validity and authenticity of the will. While the Indian Succession Act 1925 only provides for certain circumstances where probate of the will is mandatory, one may consider probating the will to secure the title and ensure no ambiguity. Is it mandatory to get probate in respect of will? A probate is mandatory if the will is made in foreign country and the executor is trying to enforce document in India for all assets located within the country. Other situations as per Indian Succession Act 1955 are when the testator is Hindu, Buddhist, Sikh, Jain, Parsi, making a will in Kolkata, Chennai, and Mumbai. These are the three places where probate is mandatory. In other than these three places, probate is not mandatory. The testator holds, here Delhi is not included, only three metropolitan cities are there, Kolkata, Chennai, and Mumbai. The testator holds bequeaths any movable property, then in that case the thing is required to be jotted down. What is the difference between nominee and heir? that I have already made it out. Nominee is the trustee, whereas here is the absolute beneficiary. Then there are types of will, but we require some time, 15 minutes, as Mayank sir has already made it out. So we will halt it for a while. And if there time be, then we will continue with the types of will. Privilege wills are there. Then essential conditions are there. Illustrations are there. Then second thing, unprivileged wills are also there, which we need to cover up. This is the second kind of will. Then the third type of will is non-competitive oral will, which is being considered as important will. Holograph of will is the fourth important part, which we need to learn. Inofficious will is the fifth part, the type of will which we'll have to look into. Then mutual wills are reciprocal wills are there. That Gita bequeaths all her property to Gita, Sita bequeaths to all to Gita, Gita bequeaths to all Sita. These are mutual wills. Then joint wills are there, husband and wife making will together. Most common part is husband and wife. Then contingent will is also there, depending on certain event. Duplicate will is there. By mistake, two wills are being signed by both the parties in itself. Statutory will is another part that we'll have to look into. Then deathbed wills are there. Pour-over will is there. And living will is there. I would like to specify 2-3 sentences on this living will because it is a new concept that ultimately Supreme Court has laid down for India. This is quite a bit different matter which we need to look into so far as euthanasia is concerned, because living will is a different concept separately from that euthanasia, which ultimately is mercy killing, or you may call it as a allowing the concerned person to die as per his own wish. That is why the living will is required to be understood. Now, there was a Supreme Court decision in the matter, and this living will has come to surface in itself. And now, recently in Mumbai High Court, also they are given some instruction about the medical will, that the living will now confirmed, made into two parts in itself. One is the medical will in itself now. If the concerned person has made a living will wherein he has specified that after finding that he is going into vegetative stage, or he is not capable of in a position to fight the illness that ultimately is being facing into cancer, or severe pain is there, and the family members are also finding it difficult, but he has made some will that in case of medical care which is required to be removed because of the vegetative stage or some other matters in itself, then my medicine should be stopped and I should be allowed to die. So once that is being said, then in that case, if that particular clause is there in the will in itself, then the Supreme Court and Bombay High Court now recently has made it out that there should be a panel of three or doctors in itself. They should decide that whether the pain is capable of being recovering, the pain can be capable of being removing or not. If the pain is not capable of being removed in itself, then in that case, and there are no chances of he being living long in itself, then the medicine can be stopped, or that catheter or some other medical instruments which are ultimately being used for making him live in itself, oxygen, etc., those can be removed. And that is where the living will comes into picture. But one point which I just wanted to bring to your notice is that despite the fact that you write in a will in itself that you should be given a chance in itself, that my family member should not suffer, that is not sufficient, and that particular aspect is not taken care of by the Supreme Court or by the Bombay High Court. And as a result of which you find that ultimately the result whether the person should be given medical treatment or not is not dependent on their family members or the desire of the concerned person who ultimately is suffering, but it is the panel of three doctors, whether there is a living will or not. The doctors panels will decide that whether the person should be given medicine or not. And once that is being done, the matter has to go to the court in itself, and then they decide that already the person is suffering and the medicine should be stopped. Doctors also cannot take the decision on their own. They have to apply to the judicial magistrate in itself. The magistrate again visits the hospital in itself, sees the condition, and then makes opinion. If he also concurs with the three doctors in itself, then the medicines can be stopped. But if the concern just says that no, no, I don't agree with that, then the another special feature again have to follow. At tribunal level, the matter has to go. But the major thing is that still as of today, recently in the United Kingdom, the anesthesia has been legalized in itself, but not in India. Yeah, we will have to wait for another 2, 3 decades now to see that this particular provision is being specified in itself. So, Pranav, you can start with question and answers.
Again, thank you so much, sir. I'm sure that could have been really very insightful. So one question here I've got is original will is registered. Subsequently, the will is revised, but the person dies before the registration of the revised will. What is the position of law? How do we ensure that the revised will come into picture and will be acted upon?
Very good point that you have made it out. There are two types of will now which are in process in itself. The first will is if it is registered. In that particular case, if the second will is not registered, then in that case, the second will have no validity in terms of law, because the law says that if the earlier will is registered, you have to do the same thing, codicil or revised will, which has got to be registered in itself. So in that case, there are two cases, registered will and unregistered will. Registered will prevail in all matters. Unregistered will have no effect so far as the technicalities are concerned.
Okay. Then one question is, inherited property cannot be accommodated in a will. Is the statement correct?
Yes, you are right in that particular sense, because the right of the concerned person in a Hindu undivided family is overall, which means that in each every category he has got certain share. It is not that property is segregated and given to that particular person. So it is just like a case of a cow owned by 5 person. Nobody knows which part belongs to A and B and C and D and E. As a result of which, it becomes very difficult to make it out what things are required to be carried out. And that is the reason why we need to look into the matter and find out that the property which is of ancestral category falls into the category of an impartable estate, which is not divided at all. How you can be the owner? You are the owner in the entire property. For example, a house is there. You are 1/5 owner in the property. Which part belongs to you? Nobody knows. So that is the reason why the property is not being identified. It is not capable of being willed by the person so long as the partition is not being made. So once it is partitioned and you become the owner of the identified share, it can be willed in the will in itself as well. But normally this partition is not there, and that is the reason why ancestral property cannot be willed out in the technical sense, though you may specify that your share is capable of being transferred by way of a will. But you need to be very specific about identity of the property, because simply saying share is of no help in itself. Nobody will be in a position to give that particular share. The distributor, the guardian, as well as the executor will not know what kind of share that he has been having. And as a result of which, it is incapable of being transferred from the uh, Hindu undivided family to the legal beneficiaries are concerned. Only symbolic transfer will be there that has no value in the eyes of law. So you need to be having identified property. Then and then only you can transfer. You have to make a list of it. These are the gold ornament. These are the silver ornament. This is my house. That is my house. Or and then you cannot simply say that I have got a share of 1/5 in 10 buffaloes. You cannot say that you are the owner of 2 buffaloes. You say that you are having 1/5 share in 10 buffaloes in itself. Which share that you are having unidentified, and anything which is unidentified cannot be transferred.
So one more question. While making a will, is it necessary to specify all the immovable or movable properties? And connected to this question, is obtaining probate compulsory in India even if there is a valid will? Because many times bankers do ask for the same.
Very good question that it has been made it out, whosoever has made that. whenever you are preparing a will, both movable and immobile property is required to be specified in the will in itself, that on a particular day. And then there has to have a residuary clause. In that residuary clause, you have to specify that anything which has not been enlisted just here in above, if you find out certain property not listed here in above, that can be distributed in the following proportion. So that will cover up the entire matter of the property. About the second point about the probate, that what he just mentioned, that there are only three metropolitan cities in the country, in India. One is the Kolkata, the second is Chennai, and the third is Mumbai. Only in three cities or metropolitan cities, if the property of immobile property category is located or movable property category is located, then only probate is mandatory. Other than this, no probate is required as per the decided case law of Supreme Court of India. Note one point, even Thane is not incorporated or included in Mumbai. Mumbai is different, Thane is different. So Pune is also, if you someone die in Pune or Ahilya Nagar or Chhatrapati Sambhaji Nagar, mandate probate is not at all required. But many chartered accountants and lawyers even don't know that other than these three cities, probate is not mandatory or not required because of the Supreme Court decision ultimately given by the Supreme Court some 15, 20 years back.
Okay. Whether will can be registered later, that is after 10 years of demise of the writer.
There is no bar about limitation factor is concerned. Will can be registered at any point of time. Registration is important. Once the registration is done, you can make the will. Otherwise, in the first 10 years, if you die, what will happen? That risk already you are covered. So it can be registered at any point of time. There is no bar. It should be registered is my suggestion.
Okay. In case of an agricultural land and in absence of will the property be divided equally to all the legal heirs?
No, there is no problem because it depends on the Fragmentation Act, whether you can have a fragmentation or if you cannot divide it on the basis of the partition in that. You have to transfer the entire property in the name of 5%, and then they will have to get it divided amongst themselves. Initially, on the death of the concerned person, agricultural land, because there is in Maharashtra or in some other states also, there is a clause that the agricultural land can be transferred only to an agriculturist. Now, in that particular case, the exception is there only in case of transmission. So, in that particular case, the property can be transferred, but under the fragmentation law, you cannot divide the property and then transfer. As a result of which, if the property is of small size and small number in itself in the R's are being concerned, then in that particular case, the entire property can be transferred in the name of all legal heirs jointly. And then they can think about getting it transferred in their individual names by getting a partition within themselves.
So one more question. Can we create a will in favor of in the favor of third person without consent of family? And can will be even created in name of guardian itself?
Will can be created in the name of third person. There is no problem. If the property is self-acquired property, it can be given to a stranger also. There is no bar on that. There is no complications also in that because there are certain feuds that normally come across, and there is a specific type of will that has been specified in officious will in itself, wherein you notice that the entire property of the concerned person is being transferred to a stranger rather than getting it transferred to their legal heirs. So that will is permitted. Even the will that has been prepared has been accepted to be legal will, valid will by the courts in India. So there is no problem about that. It can be given to a stranger or to a Tom, Dick and Harry, which is known or not known to the testator as well.
Okay. One last question, sir. If the doctor's certificate is after the date of will, can it be challenged on the ground of the date?
Doctor's will is taken after the death of the testator.
Yeah.
No, that is not permitted because the doctor has to verify the legal position as well as the mental and the medical position as on the date of signature, as at the date of execution. And then he has to certify that whether he's in sound mind or otherwise. If the person is in a sound mind state of affair, then only the certificate is being required. Otherwise, it is not required. So in that particular case, if it is obtained later on, it will not be having any evidentiary value in terms of law.
Okay. Yes, sir. Thank you so much, sir, for answering all these questions. I'm really glad that you gave your valuable time. And I could even, in the questions, there were few comments which said that very resourceful, amazing person, good knowledge, and lot many valuable feedback was there for you. So I couldn't read that because I was just stating the questions, but I could see that many of them have like, and I believe when people ask you questions, that means they are interested and they are learning more and they are paying attention to what you're saying. So the number of question itself says that yes, your session was really very insightful. And as always, I have like listened to you many a time. So I'm really glad that I got this wonderful opportunity of hosting and moderating this wonderful webinar. On behalf of the entire committee of CCL, ENNC, thank you for giving your valuable time for a very important subject that is will, because many a times people face a lot of trouble and challenges. They don't know the importance of will and what are the intricacies which they need to consider while drafting. But your presentation was also very amazing and it covered each and right from scratch till the end, from A to Z, we can say that you tried to cover each and every part. So we are really glad to have you here, sir, and thank you so much. To the wonderful audience, I even propose a vote of thanks to you from the entire committee, because I believe the entire session is not complete without your participation and without your active involvement. So you were quite involved and you even shared a lot of insights and questions to us through the link which we had provided you. So stay tuned for our upcoming sessions as well. We have multiple sessions which we are lined up. So it is all about upgrading yourself and updating yourself with the knowledge which we gain. So yes, thank you so much, all of you. And with this, I end this wonderful webinar. Thank you. Have a wonderful day ahead. Bye-bye. Take care.
Thank you, Pranav.
Yes, sir.